The Voting Rights Act was successful in its goal of increasing the percentage of African Americans and other minorities who were registered to vote and who were actually allowed to vote. It's for that reason that Congress reauthorized and strengthened the law 3 times. It is also the reason that conservatives have looked for ways to undermine it. They succeeded in 2013 when the Supreme Court handed down a decision that didn't declare the Voting Rights Act unconstitutional, but which had the effect of rendering it completely inoperative. The Voting Rights Act contained a preclearance provision that required some states to get the approval of the United States Department of Justice before making any changes to their voting laws or procedures. The law didn't apply everywhere, but instead targeted only those states that had a history of racial discrimination in voting, as demonstrated through certain historical and statistical benchmarks. One of those benchmarks was if voter registration or voter turnout was lower than 50% in the November 1964 election. In the 2013 case of Shelby County v. Holder, the Supreme Court handed down a decision that ended the preclearance requirement, meaning that states no longer need to prove that changes in their voting laws will not disproportionately affect Black and other minority voters. The court did not declare the law itself to be unconstitutional. Rather, it held that the use of statistics from 1964 was inappropriate because, nearly 50 years later, things have changed dramatically. The conditions that originally justified these measures no longer characterize voting in the covered jurisdictions. The majority said that conditions had improved since 1964, and that the racial gap in Black and white voting was actually lower today in many of the covered states than the national average. It concluded by saying, "Our country has changed, and while any racial discrimination in voting is too much, Congress must ensure that the legislation it passes to remedy that problem speaks to current conditions." This was a 5-4 decision, with all 5 of the court's conservatives voting to end the preclearance provision, and all 4 of the court's liberals voting to uphold it. Justice Ruth Bader Ginsburg argued in dissent that the court's reasoning was illogical because the law was being punished simply because it was actually achieving the goals that it was intended to achieve. She noted that, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. The effects of this decision have been significant. As predicted by the dissent, Southern states moved immediately to pass laws once again designed to reduce Black and minority voting rates. Since the Shelby County ruling, at least 26 states have passed new restrictions on voting, including virtually every state of the Confederacy. These efforts picked up steam following the defeat of Donald Trump in the 2020 presidential election and his subsequent campaign to challenge the validity of that election. Republicans contend that election reform is needed to prevent election fraud, even though there is virtually no evidence of election fraud actually occurring. And these reforms tend to target minority voters with precision. For example, minority voters are more likely than white voters to vote by mail, and therefore many states have placed restrictions on mail-in voting. Similarly, minority voters are more likely to engage in early voting than white voters are, and therefore, many states have reduced the amount of time available for early voting. In the 2020 presidential election, Joe Biden won 2 states, Arizona and Georgia, that normally vote for Republicans. Both states are controlled by Republicans, and they have both instituted a series of changes designed to help make sure a Democrat doesn't win again. For example, in the name of ballot security, Republicans in Georgia dramatically decreased the number of ballot drop boxes available throughout the state. They limited it to 1 drop box per county, which is a significantly greater burden on urban residents, who tend to be minorities, than on rural residents, who tend to be white. The Supreme Court's argument in gutting the Voting Rights Act's preclearance provision was that it was so successful that it wasn't needed anymore. Theoretically, if conservative efforts to suppress the minority vote are successful, then the racial gap in voting and voter registration between whites and non-whites will grow once again. If that happens, presumably Congress could pass a new law, using the new statistics demonstrating racial bias, and reinstate the preclearance provisions. But if the law once again proved to be successful, then it would have to be stopped once again. The court has created a vicious, illogical circle. And once again, minority voters are its victims.